The Honourable Member, Catherine Delahunty.
Thank you, Mr Chair.
Tēnā koe.
Tēnā koe and tēnā koutou te wharenui. It's not great to be here. I think we should be in select committee. I really do. And I'm very, very disappointed that we're not, because this is a very serious oversight on an issue that, if there's all these years of angst that have gone on, we should be talking to the people who are experiencing it. And they're watching. Never imagine they're not. We are being watched as we speak. I had an email just a little while ago from a carer who said, I quote, "I am just appalled that the government continues its discriminatory and exploitative process against families caring for severely disabled people." And this is what she does. What part of 168 hours in the week allows for only a maximum of 40 to be funded when you are the parent carer? What do these people think we do? Go out on the tiles? Off duty after 5 p.m. till 8 in the morning? Disappearing every weekend? Should our funding be based on their ivory tower understanding of what happens? How do they get this 18-year-old number? I understand that those under 18 have been allocated funding for care, but why can their parents not be funded as any other carer is? Do 2 parents at home get paid and only one that's left because of death or because a partner leaves? Can that person get paid if they're a spouse? I'm just flabbergasted that spouses and partners continue to be exploited. And so perhaps the Minister could answer her question. Are spouses able to be paid? We would really like to know. Because of the situation. This is outright discrimination, she says. Are the government wanting more legal action? No doubt that further legal action could delay things and be their cheaper option, which has certainly been a strategy from the last 18 years. This causes total stress and added insult to injury with an already very difficult situation. People who care for severely disabled people need all the help that they can get and that they are assessed as needing. These battles are real struggles for the carers who should be helped, not hindered. It's not clear if children catering for parents are allowed payment. That would be another question that she would like to answer. A very disappointing budget for people with high or very high needs, whom it was supposed to be aimed at. The court action deemed that funding should be for the assessment and allocated funded hours that the Ministry of Health would be prepared to pay to anyone else. Why are they now saying we will pay parents only what we feel like? But yes, anyone else can get paid their fully allocated hours. Why is the start date October? Promises for June were made. And this is really true. 2013, the promises were made after the end of the court case that there would be a resolution by June 2013. And as she says, no one is holding their breath because they've been through so many promises, so many dates have been set. And after the court case a year ago, it isn't that the government has chosen to take the opportunity to do something wonderful. They have no choice. They would be in breach of law if they didn't act. Also had an email this morning from a very experienced advocate who works for disability groups, and he said, I'm just summarising the policy from what I can read from the regulatory impact statement, and I have to say that it gets worse and worse, but don't worry, once this is through there will be heaps of sector resistance. So that's not good news, because people have got better things to do than fight the government when they're dealing with issues of their own family members or themselves needing care for disability. It's really, really disappointing to set up another round of conflict, even though the bill certainly does its best to shut down any options for complaint. But the human spirit, Mr Chair, is not like that. The human spirit will not be told that it does not have rights, and will not be told by any government that it will put up and shut up and has no right to complain. And this is a breach of the Bill of Rights, which is clear. And so the people out there who are involved in this issue are not going to, after virtually 20 years of litigation, they are not going to just give up because the government says they have to. Let's get real about this. There is going to be more challenges, and we have a better path we could follow. We could follow the path of engagement. So let's have a look at the process, which is why the Select Committee not being held is such a disaster, because what's happened up till now has been pretty bad. There was eventually, after the last case was lost and the government realised that they would look like fools if they appealed it, and it was throwing away, they'd already spent several million taxpayers' money fighting these cases, there was a decision to have consultation process. Now, the consultation document was indeed a novel of interesting proportions. It had a sort of Tolstoyan War and Peace, this mainly war aspect to it, because it made it very, very clear that there would be the possibility of taking money away from other parts of the sector if the people consulted chose the wrong path. So there was always this implied threat that actually you better be careful and not want too much, you people who already have nothing, because if you do, it will be taken off other people in the sector. A very good message if you want to divide and rule what is already quite a divided and difficult sector. Because people have very different needs and very different experiences of disability, and they don't need to be divided and ruled by being threatened. And the consultation document actually resulted in a lot of angst and anger from people who did go to the meetings and did want to engage very seriously with the issue. So then there were some options put up around whether WINS could manage it. And not surprisingly, the families and the people with disabilities went, oh no, we will not become part of the WINS machine. We will not be treated as beneficiaries. We will not be treated the way beneficiaries are treated. We do not want to. We have enough experience of this. We want to be treated as people doing a job. And who can blame them? Because the WINS machine, the work and income as it is actually called, work and income machine is not a compassionate, liberating, transformative support machine. Those words have very little to do with what happens on the ground every day in work and income. So that's why people wrote that option off. They definitely didn't want that option. The other options were around getting an allowance or being an employee. And both of those have fishhooks in them and also have possibilities. The government says it claims to have chosen the employee model, but in reality, when it says that people can be paid less for this, Mr. Chair.
I call the honourable member, Catherine Delahunty.
Thank you, Mr. Chair. When the government says that people can be paid less if they are a carer who is a family member rather than one from outside the family, this is clearly not a normal employee situation. It is clearly discriminatory, and that's where there will be more trouble to come. Because in reality, we have to decide if people are we going to recognise their work, and the Human Rights Tribunal, the High Court and the Court of Appeal have all said it's discriminatory not to, then we have to pay them a fair wage. It's pretty fundamental that people should be paid a fair wage. So what happened after the consultation? Well, after that consultation round, there was a silence. There was a deathly silence, which involved people like me being rung up constantly by other groups saying, have you heard anything? What's going on? So, I sent a few questions through to the Minister. In due course was the reply, but there was no information about where we were going. This is the 21st century where sophisticated community consultation processes can be facilitated, but this didn't happen. And I do go back to my own father, who always said that consultation is a cross between a con and an insult, and I do find that has a certain resonance in this case. Because what happened was they then set up a technical working party. There was considerable effort by some of the families involved in the litigation that they would like to be represented as experts. Because if there's a fundamental issue here, which is these people are experts, Minister. They have lived and breathed what you and I possibly have not. And they know that there's a need to be fair and reasonable around state money, because they've lived with minimal state money for a very long time. And they are not expecting a banker's wage. They're not expecting an MP's wage. They're not expecting a consultant's wage. They want the basics so they can survive with dignity, and so can their family. This bill refuses to deliver that. So they should have been included in the technical working party, and they were not. One person from the carers groups was included, and after 3 meetings there was a shutdown. So no one outside the technical working group were no longer involved. The Ministry of Health went back, and the Minister, and they started talking about it without involving anyone else. And this is the result. This is the result. It's a paranoid, fiscally cheap option, which could have been so much better if they'd kept the door open, if they'd kept talking to people and kept engaging, because I think it would be fair to say that most of us realise that we cannot just write a cheque, unlimited cheque on this issue. We have to recognise the constraints. But those constraints should be defined by the human needs of the people. The people themselves should define those constraints, not the Ministry of Health and the Minister, who have resisted every step of the way and have written into this bill that they basically don't believe family members should be paid, but if the court's going to make us do it, oh well, we'll find a cheap solution. And so the bias, the prejudice and the invisibility towards the knowledge and expertise of people of disabilities and their families is now going to be entrenched. So with that description of what's happened, we now find there's no select committee. So where is the expertise going to come from? Where is the knowledge going to come from to make an assessment? So we're going to go into third reading without hearing from the families, without hearing from the people with disabilities who have many ways of speaking about their experience and would like to speak to us. And our job, Mr. Chair, is to listen to those people about how we can fairly meet their needs. Our job is to hear them, not to set up a short consultation process, threaten them that you're going to take the money from another part of the sector and then lock things down while you make up a solution that is fiscally safe for you but perpetuates discrimination to the point at which the Attorney General says it's actually a breach of the Bill of Rights. So, where are we going to go with this? Back to court? Are we asking people who are already stretched, who are already broken? They're not allowed to go back to court in this bill. They've been told really clear in this bill they can't go back to court. There is no court they're allowed to take it to. As for what they've done to the Human Rights Commission and its status, it's very interesting because presumably the government believes in human rights and the Human Rights Commission and the Human Rights Tribunal. But they have said that the most vulnerable citizens, the most marginalised citizens, who are people with disabilities and their families with high needs, have no access. It's very bizarre that those with money and those at the highest level of society in terms of material wealth will have access to the courts and the land if they get into trouble. And strangely, they seem to do with other people's money sometimes. But the most vulnerable will not. And that's written into the law. And I'm really ashamed.
Shall I toss a coin? I'll go for. I think I'll go for